Do you have an irate neighbor that keeps trespassing on your property? Or an out-of-line coworker who's creating a hostile work environment? Or what about that hopeful lover who won't stop texting or calling despite repeated requests to stop? Or maybe you're the one who's been slapped with a peace order. I'm Morgan Leigh, an attorney with Markham Law Firm, here to talk to you about peace orders in Maryland. First, I'm going to talk about what a peace order is and what it does. Then I'm going to tell you how to obtain a peace order. And finally, I'm going to explain what you should consider if you've been served with a peace order. So what is a peace order? A peace order, also known as a restraining order, is an order issued by a court directing a particular person not to contact or attempt to contact the petitioner for 6 months. The person who filed the petition for a peace order is the petitioner, and the other party is called the respondent. Violation of a peace order is a criminal offense, punishable by up to 90 days in jail for a first offense and up to 1 year in jail for a second or subsequent offense. Other forms of relief that a court may grant are ordering a respondent not to enter the petitioner's residence, ordering a respondent to stay away from the place of employment, school, or petitioner's employee, directing a respondent to participate in counseling. So how do you get a peace order? First, you must fill out a peace order petition and file it with the district court clerk. You can also file a petition with the commissioner outside of business hours. This form can be obtained online on the Maryland Court's website or at the courthouse. You'll be placed under oath and provide testimony as to why you're seeking a peace order. You should bring any supporting evidence like emails, videos, or texts, but this is more important for the final hearing. If you file the petition with the commissioner, you may be issued an interim peace order and will need to appear before a judge to obtain a temporary peace order on the first or second business day following the date that you obtained the interim order. For a temporary peace order, the petitioner must show that there are reasonable grounds that the respondent committed a prohibited act against the petitioner or the petitioner's employee, and that the respondent is likely to commit an offense in the future. A final peace order hearing will usually be held a week after the temporary peace order. At the final hearing, the petitioner must show by a preponderance of the evidence that the respondent committed one of the following acts: an act that causes serious bodily harm or places the petitioner or their employee in fear of serious bodily harm, assault, false imprisonment, harassment, stalking, trespass, malicious destruction of property, misuse of telephone facilities and equipment, misuse of electronic communication or interactive computer service, revenge porn, or unlawful visual surveillance. So what if you've been served with a peace order? If you find yourself in the position of having to defend against a peace order, there are a few things to consider. First, you should consider whether to consent to the peace order or to fight it. Second, you should gather all your evidence in your defense to present to the court. Finally, make sure that you do not contact the petitioner directly or indirectly, as that can subject you to criminal penalties and hurt your case at the final hearing. If the court makes a finding that a prohibited act occurred, you can appeal the ruling to the circuit court within 30 days and consider whether to consent in the circuit court. While a peace order is not a criminal record, it may be viewable on certain websites unless and until a court grants a motion to seal the records. While a lawyer is not required to file or defend against a peace order, a lawyer can help you best explore the options, assist you in presenting your evidence, help keep evidence out or admit evidence to help your case. A lawyer can also advise on how to remove any public record of the proceeding. In addition, a lawyer can reduce your stress by explaining to you the process from start to finish. If you found this video useful, please subscribe to our YouTube channel in order to look out for more videos in the future. Thank you. Morgan Leigh with Markham Law Firm.